Morning, everybody. As David said, my name's Nick. For those who haven't met me before, which I suspect is probably most of you, actually, I've seen a few names that I recognise, but most I don't, to tell you the truth. I am a partner at Forbes, as David said. To get a quick plug in, for those who don't know Forbes, which may be a fair few of you, Forbes is a full service law firm, but we have a large insurance team, around 50 advisors across offices in central Lancashire, Manchester, and Leeds, and we cover off all aspects of insurance. My background is mainly complex claims, predominantly in the construction sector, which includes sort of policy advice type stuff, which is why I've been asked to speak today, really. And I'll start by saying thank you to the Institute for inviting me. It's much appreciated, and it's good to hopefully give you a bit of a refresher and some other new bits around the Third Party Rights Against Insurers Act. So hopefully I can share my slides and you can all see that. If anybody can't, shout or put something in the chat or something, but I'll presume that you can see it. So yeah, the plan for today is to cover off Third Parties Rights Against Insurers Act 2010, which I'm going to refer to as the 2010 Act to try and save my voice and avoid tripping over my words throughout. So I'll do a bit of a background on that and kind of a refresher, really. I think my experience and from speaking to David beforehand, it doesn't come up all that often. So I think it's worth a quick refresher on it, and hopefully that'll cover off those on the call who are kind of new to this area as well. I'll then look at a little bit of case law in relation to the Act generally. Touch upon conditions precedent as a kind of general concept, and again a couple of cases on that, and then hopefully tie it all together with a nice bow in relation to the recent case of Makin, Protec and QBE. So that's the plan, and if we get time, we'll hopefully possibly do a Q&A. They can be a little bit awkward on webinars and Teams calls, so I will stick my details up on the final slide and arrange for the slides to be sent out to you all, and then obviously if anybody's any questions, you can feel free to either give me a call or drop me an email. That might be the easiest way around, but we'll see how we're doing for time at the end. So Third Party Rights Against Insurers Act, although it's 2010 Act, it actually came into effect on the 1st of August 2016, so sort of 9 years. It replaced the 1930 Act, but it isn't retrospective. So the 1930 Act is still applicable in certain situations, which I'll kind of touch on later. Sorry. The purpose of the Act is to simplify the position for third parties, and essentially it means that they've still got a right of action against an insured defendant where there's a policy in place. It puts the third party in the shoes of the insured effectively. It simplified matters from the 1930 Act. As many of you will know, I'm sure, that the 1930 Act was more difficult for claimants, third parties, in that if a company was insolvent, they had to mess around restoring them to the register, obtain a judgment, and then subsequent to that, bring either separate proceedings or include them as a Part 20 afterwards, add in the insurer, and then potentially face further arguments again with any defence that the insurer may had. And it also meant from the insurer's point of view that there was often a massive delay in being notified of these claims. So realistically, I think it's simpler for both sides. It now means that the third party can include insurers from the outset, where there is, or where the Act applies, in that the insured is insolvent, and there is a relevant policy of insurance in place. The other kind of addition, which doesn't come up as perhaps as much as people kind of expected it to when the Act first came into force, is that insurance details can now be requested. Section 11 of the Act deals with this in Schedule 1. So where an insured is insolvent, the solicitors for the third party, or the third party directly, I suppose, can approach anybody in effect that may have details of the insurers. So that might be former directors of the insolvent insured. It might be, or the insured themselves if they're an insolvent person. It might be brokers if for some reason they know the broker details, or perhaps even the insurer directly, if insurance details have previously been included in a contract, but they don't actually have details of the policy as a whole. And what it means is, where there is a policy of insurance, they can request, firstly, confirmation that that policy does exist. And then on top of that, they can request details as to the terms of the policy, whether there's any issues about the insurer reserving rights or looking to withdraw cover, any proceedings which are pre-existing between the insurer and insured. And they can also request details of the level of indemnity within that policy, and what has been paid out against the policy, if anything, alongside details of any excess or deductible, which obviously they can't recover from the insurer, and therefore have no rights of recovering that bit of it, where the insured is also insolvent, which is obviously always the case in these third-party rights against insurers Act matters. Relatively short timescales for responses to that. A request under the Act for that information should be responded to within 28 days of receipt. So it's fairly tight timescales, but obviously it's all information that, presuming there is an insurance contract in place, can quickly be provided. So as I said, the purpose of the Act is that the third party effectively stands in the shoes of the insured under the policy. So they're also restricted to the terms of that policy. The rights aren't any greater than the insured would be. That also means that the insurer has the same policy defences that they would have against any claim which the insured was to bring against them. So, for example, breaches of various conditions, lack of notification, that sort of thing, which we'll touch on later when we look at conditions precedent. Section 9 of the Act limits that slightly with regard to conditions affecting those rights. So where those rights are subject to some sort of condition that the insured has to fulfill, for example, if the insured is required to, but it could even include notification conditions, where the reason that information can't now be provided is for the very reason that the insured has dissolved, or in the case of an individual insured has passed away, then you as insurers can't hold that information against the third party, for obvious reasons, in that the third party can't be punished for things that have happened since the insured party went into insolvency, effectively. So looking at a couple of cases just as a refresher that kind of deal with those issues. The first one, the BAE Systems case, deals with the coverage point. The argument in this case was that because BAE were arguing that the specific activity wasn't covered under the policy, then they shouldn't be included within any proceedings because of this potential coverage issue and the reservation of rights. The finding was that the claimant or third party only needs to claim rights under the policy. They don't need to prove definitively that the policy is going to respond before joining the insurer to proceedings. From an insurer's point of view, this has the effect of effectively opening you up to all sorts of claims where, yes, there's a policy of insurance to get in place for the company, but it isn't responding for whatever reason to the particulars of to this particular claim. But what the court said is that, firstly, it's case specific, where there is clearly no cover, or you've notified the third party that coverage has clearly been withdrawn for legitimate issues and can provide evidence to prove that. Then if you're included within proceedings unreasonably, then, costs would flow as they would with any other sort of proceedings where you're included either wrongly or, for unjustifiably. And it also suggested that the courts should be alive to these issues and should list matters for preliminary hearings where insurers are raising arguments around coverage within a defence to a third party's claim. That then hopefully negates the issue of you being dragged through lengthy proceedings, running up massive costs just for it to be found that there was no coverage and your position was justified in the first instance. Redmond and Zurich illustrates the point as to the 1930 Act still being applicable. This is a mesothelioma claim, so going back many years prior to 1st of August 2016, and it confirmed that what has to be applicable is that both liability and insolvency both have to be pre 1st of August 2016 for the 1930 Act to apply. And what was found in this case is that liability is incurred when the damage is caused, not when the claimant establishes the right to compensation. So it's a slightly confusing position in that insurers can only be joined to proceedings under the 1930 Act when the right to compensation has effectively been established. But in looking at which Act applies, the test is when the damage was caused and not when the right to compensation arises. So, as I say, both liability incurred. So effectively, if you're looking at a straightforward personal injury claim, then it's date of accident, or in this case, date of exposure. And insolvency of the company both have to be pre-2016, and then you fall into the 1930 Act. Obviously, if one of those things is post August 2016, then you're falling into the 2010 Act, and it's relevant for the reasons I previously set out about increased potential to request further information and the ability to join insurers from the start, which is obviously more attractive to claimants. The other change under the 2010 Act is that there is no pause on limitation. Rashid and direct savings is the relevant case law on that. So, pursuant to the 1930 Act, when insolvency hit, proceedings were paused for that period until the company was restored. Now, because claimants have the right to immediately include an insurer in proceedings, either from the start if the insured is insolvent prior to the proceedings being commenced, or immediately upon them becoming insolvent if we're mid proceedings, then limitation doesn't stop. It continues running. So that's something that claimants need to be alive to, and we as insurers need to be alive to when claims are presented, to ensure that they have been brought in time. And the final point on the Act, which deals with those requests for further information, is the Peelport shareholder case. In this case, the claimant had requested insurance information, and they'd requested that information on the basis that they believed that the claim was at such a level that if they succeeded with the claim, it would essentially put the insured company into insolvency immediately, and they wouldn't be able to satisfy any judgment. But the issue was that the insured was still solvent at the time that the application was made. So what the court said was, this is not an application under the 2010 Act for further information, because it can't be, because the insured is still insolvent. It doesn't matter what the impacts of some notional judgment may have on the company. The insured is still solvent at this time, so this just falls as a standard CPR pre-action disclosure application. And with that being the case, there's ordinarily no requirement to provide insurance information by way of pre-action disclosure. It's not relevant to the facts of the claim itself. So the application was dismissed on that basis. So it's just something to bear in mind if and when insurance details are requested. They can only be requested where the 2010 Act actually comes into play, which is essentially where the insured is insolvent, not just generally across the board. I thought I'd just deal a little bit with, apologies, my slides are playing up a little bit, with conditions precedent as kind of a general concept and a bit of a refresher, and then look at how they apply to the Makin case. So obviously, conditions precedent, a condition precedent is a condition which has to be met before either the insurance contract itself comes into play, or a condition which has to be met for a specific condition or provision within that insurance contract to come into effect. So there's essentially two types, as I'm sure you're all aware. Condition precedent to validity, or to cover as a whole. So for example, payment of your insurance premium. A breach of one of those conditions will mean that effectively the insurance company was never on cover. The second type is condition precedent to the claim or to your liability as an insurer. And the most common form, I would suspect, is that of notification of claims. And that's kind of the one that crops up the majority of times in case law around this issue. So how do you know if a condition is a condition precedent? And that's the question which does kind of raise its head most commonly, I suppose. Ordinarily, the obvious, they will be labelled a condition precedent, but it's not always the case, and also not entirely necessary for a condition to be found to be as such. So there's a couple of cases there on that issue. The real crux is that there should be express language, and particularly as to the consequence of any breach of that condition. So the Kidson case is a little bit of backwards wording, I suppose, is the best way to put it. In that the wording was a claim will essentially only be dealt with where such notice having been given. So the kind of flip side of that being that the insurer wouldn't deal with the claim if the notice hadn't been given. So slightly bizarre wording, but the Kidson case involved professional indemnity insurance policy, and the policy was on a claims made basis. So another key point from this one was the requirement for specific notification of each and every claim. It involved a bit of a bizarre notification of the insured essentially just providing a ton of documents to the insurer and basically trying to allege that that constituted notification of the 300 or so claims which arose during this period because they were vaguely mentioned in documents. And what the court found was that there has to be specific notification of each and every claim. It's not enough to just provide a kind of blanket claims policy, and because the policy had this condition, albeit not labelled as a condition precedent, that required notice, then the majority of claims were denied. The Cuckoo and AXA case is one that is mentioned in the Makin case, which we'll talk about in a second. And again, that involves condition precedents not being labelled, but the wording was sufficiently clear that the court found that that was a condition precedent, and the wording is may lose all rights cover under the policy where there is non-compliance. And specifically, it stated that you must, as an insured, do certain things. In this case, it actually related to the provision of information and documentation, which was provision of defective cavity wall insulation was what Hooker as a company had been involved in previously. And the information again was lost or destroyed upon the company becoming insolvent, and it was found that they could lose the right to cover under the policy by not retaining such information. So dealing specifically with notification, the Zurich and McAferry case is one that comes up fairly regularly, which involved a slightly weird timeline, which the Makin case kind of does reflect a little bit. So it involved a defective product which was supplied by the insured company. That was then hired out by by another company, and then used ultimately by the third party who was eventually trying to bring the claim against the insurers. So whilst the company producing the product had been notified of an issue with the product and that it had been taken off hire, they hadn't been notified of the actual circumstances surrounding the issue or any more background to it. And specifically, they hadn't been notified that a serious personal injury claim was arising out of the defect, or that it was alleged that the defect had caused that personal injury. So the terms on that one were that as soon as possible after the occurrence of any event likely to give rise to a claim. That was the requirement for notification. And the question before the court was, well, what constitutes likely to give rise to a claim? And the court found that means that there is at least a 50% chance that a claim will arise, judged on an objective basis, basically, by a reasonable person, a reasonable insured in the position. they said that if the insurer wished to exclude liability, then it's for the insurer to ensure that wording is clear. Obviously, the impact of withdrawing cover on an insured is serious. Therefore, any ambiguity in the terms must be found to be in favour of the insured, essentially. So it's incumbent upon the insurer to make sure that their policy wording is clear and that the insured are aware of the requirements on them and the results of that. And they found that they hadn't done so. Clauses need to be clear. In this case, it was the court's view that likely to give rise to a claim, as I say, means at least 50%. The information that they had when the insurer were suggesting that the claim should have been notified to them was simply that there had been a defect with the product. It wasn't any more than that, and that on its own wasn't sufficient to put them on notice that there was likely to be a claim arising from that. They notified the insured when they were ultimately included as a Part 20 defendant in the claim, but crucially, they did receive no real correspondence, no letter of claim from the claimant directly. And as I say, they were only included as a Part 20 claim by the hire company, and were never made aware of the claim by the claimant, obviously, prior to that Part 20 claim coming about. So on that basis, cover applied. There's no reason or no justifiable reason for Zurich to pull cover, and they were required to meet the claim. The Jacobson Costa is just an example of the same wording, essentially. It's a long-standing authority. And that really reinforces it. The point is that a possibility of a claim is not enough to engage the obligation to notify your insurers, where the wording is that something has to be likely to give rise. So it's really flagging the importance of wording, I suppose, and specific wording as to the applicability of the contract. You can contrast that with the Rothschild assurance case, which we just mentioned at the bottom, which had much wider wording in that the words were may give rise to a claim rather than likely. And in that situation, the question or the test to be applied was only whether there was a possibility of claims in the future rather than an actual likelihood. So the barrier in that case was considered to be a lot lower than the 50% suggested in the Makin case. So that brings us on to Makin, and hopefully you'll be able to, or we'll be able to, tie together all the concepts I've been waffling on about for 20 minutes into one nicely applicable case. So Makin and Protec was a personal injury claim arising from a claimant being ejected by a bar. Not too far from here, actually, there's a bar in Oldham, Muse Bar, if anybody's visited. If you have, don't go around throwing glasses on the floor. You might be put in a headlock by the security staff. The claimant was, as I say, ejected from the bar by the security staff. He was restrained, held in a headlock for a prolonged period. But crucially, he got up, walked away, went home. Immediately post restraint, seemed to be absolutely fine. Later that night, suffered a severe stroke, and ultimately it resulted in a personal injury claim being presented worth in excess of £1 million. It was defended by Protec, Protec being the employers of the security staff who were contracted by the bar. It was defended by Protec and listed for a trial on a preliminary issue being both a preliminary trial on liability and on causation broadly as to whether the actions of the security staff and the headlock could have caused the stroke, essentially. 1 day prior to that trial, Protec appointed liquidators, so they were entirely unrepresented at the hearing and ultimately found vicariously liable for the door staff's actions. QBE were then joined to the proceedings as the PL insurer for Protec after that trial of a preliminary issue. There was no argument that the 2010 Act applied. The claimant is obviously a third party. The company were a relevant person under the Act in that they had gone insolvent, and it was agreed that a policy of insurance theoretically would respond. It also wasn't an issue, as we touched on at the very beginning, that the claimant's rights under the policy, as they now fall because they're standing in the shoes of Protec, couldn't be any better than Protec's rights were as against their own insurer. QBE's position was that there'd been late notification and therefore they were entitled to full cover. The claimant's argument was, firstly, that there hadn't been late notification, and secondly, even if they had, then that wasn't a condition precedent under the policy. It was only a policy condition, and they argued that on the basis that they said that it was at the insurer's discretion whether they wanted to pull cover.
You're looking for professional grade sealants that offer technologically advanced performance. Choose Boxley Pro Sealants.
Sorry, not sure what was going on there. So in terms of the background to notification, so the bar themselves, Muse Bar, received a letter of claim in October 2019. That was sent across to Protec in December 19 on the basis that the security contract had been contracted out to them. They were responsible for the doorman's actions, essentially. A letter of claim was then ultimately sent to Protec by the insurers, the claimant solicitors in June 2020. And they then forwarded that letter of claim on to QBE directly in July 2020. Now, the position which kind of complicated all this was, as I said at the start, the claimant's evicted from the club, but seemingly uninjured, gets up, leaves the scene. And Protec's position was that they witnessed that, the door supervisors, their view was that the claimant was uninjured. And therefore, at that point in time, post-accident, they had no requirement to notify their insurers of an incident. What complicated matters, I suppose, for QBE is that the incident was investigated by the police in 2017, within hours of it happening. Or actually, sorry, the next day, because it was post-stroke. The doormen were interviewed by police, but ultimately released without charge. QBE's position was that an incident investigated by the police shortly after the accident itself, and crucially within the 30 days which the policy required notification of an incident, was clearly something which had the potential to give rise to a claim. The claimant's position was that because he seemed uninjured, that requirement to notify essentially didn't arise at the time of the incident, but only arose later upon Protec receiving an actual letter of claim, essentially. The police investigation was kind of the crucial point. The court found that Protec were aware, or at least reasonably should be considered to have been aware, that this incident may give rise to a claim given the police investigations and the fact that at that point Protec or their employees were aware that the claimant had suffered a serious stroke, and the likelihood is that that stemmed from the actions of the door supervisors. The question then fell as to whether notification under the contract was a condition precedent. It wasn't labelled as a condition precedent, but as we've dealt with previously, that isn't necessarily crucial. The notification requirement was included at the start of the policy in a section headed Claims Conditions, and that section read that any breach of these conditions will entitle us, the insurer, to refuse to deal with the relevant claim. The claimant's argument was that that was a discretionary right, in that they could refuse they could choose to exercise the rights under that section if they chose to do so, essentially. If it was intended to be a condition precedent, then the wording should have been clearer and not simply an entitlement to withdraw cover, but that cover would be withdrawn specifically. And they referred back to the Zurich and McCaffrey case that we mentioned earlier, essentially saying if there is any ambiguity within the wording, then that should be decided in our favour. And they argued that there was indeed ambiguity within that wording, and therefore there was no right of the insurer to withdraw cover. Another kind of bizarre position in this policy was that condition precedent as a term was used in other sections of the policy. And this point is a little bit of an awkward one. I think that this may be one of the crucial things that comes up in any subsequent appeal on this. Because the claimant's position is that essentially general contract terms apply. You would apply the same meaning to wording throughout a contract. They've used condition precedent as a specific term in other areas of the contract. Therefore, any terms which don't specifically state condition precedent shouldn't be considered as such. I think it's a fair argument, and as I say, it is one that QBE may have problems with on subsequent appeal, but we'll kind of see how that goes, I suppose. QBE's position is that the wording isn't ambiguous. They will say that payment's conditional on notice, and specifically the words will and entitle suggest that there is no discretion there. It's that they will refuse to deal with the relevant claim. And the court agreed with them, essentially. they believed that the use of the word will in particular got rid of any ambiguity in that contractual term, and meant that where notification wasn't provided in accordance with the contract, then they will withdraw cover, which they did. And the court's belief and the finding in the judgment was that the true meaning of the language was clear, without any label of condition precedent specifically. And it was still entitled to be considered a condition precedent, regardless of the arguments surrounding it not being labelled as such, and the phrase being used elsewhere in the contract, as I mentioned. Ultimately, the finding was that compliance with the claims conditions is a condition precedent to liability. I mentioned the Cuckoo case specifically, which we dealt with earlier, surrounding the specifics of wording and compliance being required. And I've just added this this little snippet from the judgment, because claims under this Act are slightly bizarre, I suppose, particularly in the personal injury sphere, in that essentially the person responsible for the claimant's injuries is getting away without paying anything because of their own inaction, effectively, and it feels unjust, I suppose it is, but sadly, that's just, or sadly from the claimant's point of view, that's just the way that these things fall. You have to have sympathy for the claimant, but that by itself cannot mean that he has a good legal case. So where a defendant fails to notify their insurer of an incident, they're effectively benefiting from that, or rather the insurer is, but sadly that's, for the claimant's point of view, that's just the way the Act falls. So the key takeaways from that case, from a claims point of view, as you will do when you receive any claim, is to consider, have the policy conditions been met? I think this is more important where, for obvious reasons, I suppose, where the 2010 Act applies, because it applies solely because you're insured or insolvent, and on the back of that, it's the likelihood is that it's going to be very unlikely that you can advance any defence to the substantial claim effectively. Realistically, you're probably not going to be able to track down witnesses and that sort of thing. So it's reasonable that you would apply a kind of more stringent approach where things like notification conditions haven't been met. If an insured was solvent and perhaps they were a few weeks late, maybe even a few months, if there'd been no prejudice, you may well choose to deal with the claim. Whereas I think where the 2010 Act applies, then you really have to look at these things more strictly, where you've got an insolvent insured, and you're entitled to do so where notification is a condition precedent and it hasn't strictly been met. Then, as Makin shows, you're entitled to withdraw cover. Question is knowledge of the insured at the relevant time when you're looking at notification. As the Makin case sort of discussed, it's fact specific. How far you go post accident as to the relevant knowledge is questionable. I think you can't expect them to be constantly investigating matters down the line where the that knowledge isn't directly theirs, if you see what I mean. If, for example, like was the case in the Makin case, where they have no knowledge as to the true consequences of an incident, even if they're perhaps aware of it, then you can't expect them to make extensive enquiries as to that 6-12 months down the line just to check if a claim may be brought against them. But in the Makin case, it showed that although immediately post-accident, the insured had no knowledge that any claim was likely to arise because they believed the claimant to be uninjured. If you come into that knowledge, particularly within the period where you're still required to notify your insurer, so whether that's 30 days or whatever it may be, as it was the case in the Makin claim, then the likelihood is that knowledge acquired within that period will still be considered to be relevant to your notification requirements. So it's not enough to simply say, oh, we didn't know immediately post-accident, so we did nothing else about it, and we just buried our heads in the sand. There is still a requirement of them to notify you if they come about that knowledge within that period. And then I suppose the key takeaway from all of this is wording, and clarity of wording. Just label your conditions condition precedent. why that wasn't the case, and how that would have solved many an argument in all of these cases, I don't know. They've got around it at the moment. There is still permission to appeal on the issue of whether the conditions were condition precedent, and only on that issue. So the court still feel that there is clearly argument to be had around that. So we will see in due course where that ends up. But obviously, all that would have been avoided if the condition had simply been labelled or somewhere thrown into that sentence condition precedent. So check your wording, I suppose, is the ultimate one, and make sure that it is clear. And also, as to timescales, a few of the issues which have arose across the various cases is as to timescales when insureds are required to notify. The Makin case did specifically include the requirement of within 30 days, and that has certainly helped them with regard to the notification point, and the knowledge of the insured point that we touched on earlier. So that really is the key. So the real, I suppose, the real consideration going forward from that case is really to just check your policy wordings, and make sure that important notification requirements, whether that be claims notification or whether it be retention of documents, is one that regularly comes up as well. Ensure really that is included within either within a section of condition precedents or is clearly labelled as such. And that is everything for today. We've got sort of 9 minutes. If there are any questions, I can deal with them now if people can unmute themselves. Otherwise, my details are there. Feel free to take them down and drop me a line. You know, if you've got any questions arising from this or in relation to coverage generally, feel free. If nobody's popping up, I'll hand it back to David, I think, who's just going to give us a quick close.
Thanks, Nick. Yeah, it's a really important subject, especially now that you know, it's really important for policyholders to notify their insurers straight away, especially given that the courts have favoured the contract over whether the severity of the injuries and or the claimant's concerns. So it's certainly a really good discussion point. So far, there is no questions, but just to let everyone know, the materials are for this discussion will be made available to those who have attended. And there will be a survey that goes out as well for everyone to complete. Please do so and provide any feedback and also any suggestions for future subjects that you want to discuss or you would like webinar discussions on. And I just want to end with saying a big thank you to you, Nick. Thank you for taking the time to discuss this today. And thanks, everyone.
Thank you very much.
Thank you.
Thank you.
Thanks.